All right, so welcome to Stock in the Armory, assembling and effectively using the tools necessary for a successful mediation. I'm Nathan Shea, the chair of the ADR section of the Contra Costa Bar. With us, my esteemed colleagues, I'll go in order, not necessarily of importance. Robert Jacobs from Judicate West. After litigating for more than 30 years, Robert became a full-time neutral, received his mediator training at Northwestern University in Chicago, Illinois in 2016, serving as a neutral ever since. In 22-23, he took a leave of absence by accepting an invitation to serve as associate area legal counsel for a large multinational nonprofit entity. He was headquartered in Ghana, worked throughout West Africa. Upon his return, he became affiliated with Judicate West, where he mediates real estate, business, construction, PI, medical, and dental malpractice cases. He is designated as a super lawyer and holds an AV rating with Martindale Hubble. Next to Bob, as I affectionately call him, we have Joseph Lordan, co-managing partner at O'Hagan Meyer in San Francisco, and national co-chair of the Labor and Employment Practice Group, dedicated to defending employers in employment and business litigation and providing preventative, individually tailored advice and counseling. Practice includes defending employers in wrongful termination, discrimination, harassment, ADA access, etc. Extensive work on PAGA and wage and hour class action claims. Team also provides, again, preventative counseling to employers regarding all employment practices. Takes pride in offering clients practical advice and insights that allow them to make wise business decisions and avoid unnecessary expense in litigation. Next to Dave, Joseph, we have Maria Bourn. I'm sure you've been called worse. Maria is a seasoned professional attorney who excels in trial litigation. Passion is helping employees, so you guys probably like to talk, who have been discriminated against due to gender, race, ethnicity, and disability. Her compassion and grit to fight for her clients have resulted in multiple seven-figure verdict victories. Currently represents several clients in high-profile workplace discrimination cases, and what caught me is that one of her clients called her their guardian angel. That can't get much higher praise than that. Next to Maria, we have, actually, David Sarnoff. After graduating from Loyola in 2005 with honors, began his legal career at a large regional firm in Southern California, where he practiced real estate, unfair competition, intellectual property, employment, and general business lit. Eventually made the switch from big firm corporate representation to advocating for individuals.
Skip over most of this.
These experiences led David to start mediating, and in 2018 he received a formal mediation training at Pepperdine University Strauss Institute, wound down his litigation practice, which all our litigators are jealous of, became a full-time mediator in late summer 2021, combines his training and experience as a litigator and small business owner to help litigants realize the benefits of compromise and resolution, finding it deeply rewarding. So with that, I will turn it over to our esteemed panel.
Thank you very much, Ed. Welcome, and thank you for being here today. If you cannot hear us, let us know. We're not really using microphones, so we'll try to speak up, but if it gets a little bit faint, just put your hand up and let us know, or move closer. We have a panel of very experienced lawyers and two mediators here. I know we have some mediators in the audience, and we will give you at least our perspectives we have today, and if you have comments, questions, we're going to take those at the end. And we have a list of questions. The topic is stocking the armory, the idea being that what do you need to give from our perspective that's going to help us as mediators, and it's going to be effective for co-counsel or opposing counsel in mediation to make it effective in the resolution. So I'm going to just launch a couple of questions for our panel and kind of do a little bit of chronology. Work up to mediation, what are the considerations that go in beforehand, and then what do you do at mediation to try to make it as effective as possible. So I will invite our panel to respond to question number one. What mediator characteristics do you most look for in selecting mediator?
I'd like to jump in first. Again, my name is Joe Lordan. I'm on the defense side. I will say I've got a long list of things that I consider when selecting mediator. Sometimes the very first and most important is availability, because quite a few of our sort of preferred go-to mediators these days are booking 6 months, 8 months, 12 months out, which doesn't provide a lot of opportunity to resolve cases in a timely fashion. And then the second is oftentimes cost. And there is a correlation sometimes where cost denotes value, but also cost can signal that you are valuing the case highly to the other side. So selecting a $30,000 a day mediator on a case that you value as a $50,000 resolution doesn't work. So you have to balance both the availability and the cost. And we'll talk about some of the other issues with Maria.
Yeah, I think on my side, because I represent plaintiffs, an important mediator trait is having high emotional IQ. So I can have a conversation with them, they can have a conversation with my client, and that they can appropriately address the room. Knowledge in the area of law. I've had mediators that don't know anything about employment litigation, and often we have mixed claims that include wage and hour claims or some other technical claims, so we want to make sure that they have knowledge in the area of the law. And someone I trust. That's a big part for me. If I don't trust the person or like them, I'm not going to have a successful mediation.
I don't choose mediators anymore, thank you, Maria. I don't choose mediators anymore, but I used to. I did it for 30 years. The most frustrating mediations I had were where we would show up and we would mediate for a couple of hours or a few hours, and the mediator would say, case isn't going to settle today. And that was it. No explanation as to why, it's just not going to happen. And I was always left scratching my head going, what happened in the other room? Why are we here? There was no reason given. And so what happened is after that happened a few times, I started looking for mediators who were tenacious. And for me, that became number one on my book. Someone who's not going to give up easily, who's going to find out where I'm at before the case is not going to settle, and then good communication skills, because if I'm going to do anything else, then I can't, I'm told the case is not going to settle. So tenacity was a real thing.
Yeah. Go ahead, David.
No, go.
So there are a couple other things besides cost and availability that I'm looking for, and I agree completely with everything Maria shared in terms of this trust, emotional IQ, and respect. Some of it is I have to look at my client and assess what they need. And so if I've got a experienced C-suite general counsel versus an inexperienced small business owner, what do they need? So is that a retired judge? Sometimes having the robe and gavel matters. Or can I get away with someone that is a subject matter expert? Sometimes I have to make decisions regarding the race or the gender. Do I think that a female or a male mediator will be more effective in speaking to my client? Do I think that there are age considerations? Sometimes someone who's a bit more experienced and who's been around the block and done more things can connect more effectively and command that respect that is necessary to carry the day. If you have someone that isn't respected, it's not going to be an effective mediation. And then the last piece that I consider is venue. So post-COVID, most mediators have moved entirely to a virtual setting. I still think that there is an irreplaceable value of being in situ with the mediator and your client and with the opposing counsel and the plaintiff in the other room. And so I am also selecting mediators that are willing to entertain in-person mediations as one of my considerations of, do I need that? And I know Maria and David and I kicked that around on Zoom versus in person. Maybe it's worth chiming in on selections and criteria.
Yeah, for me, I haven't noticed any difference in resolution regarding Zoom. The only part that I've found that's more effective in Zoom is you have to spend the whole day with your client, and you get to learn a lot about them spending the day. And as to whether the case will settle or not, I haven't seen any difference.
Well, let me chime in on that. Personally, there's some benefits to Zoom that you couldn't get in person. One big one being the ability to contact one of the attorneys by phone outside of the breakout room and be able to chat with them without their client necessarily knowing, because that was always an issue pulling the attorney aside. You don't want the clients on either side to feel that they're being left out of something. So I actually think there's a benefit to being on Zoom in that regard. But I do also understand the need for in-person and the benefits of being there, going through the process in person. And so for that reason, I will do in person as well. But I don't think that Zoom is just a negative. I think there's some good stuff about it.
Thank you, David. I'll shift gears for a minute and move to before the mediation preparations. So, question really targeted to Maria and Joseph. How do you best prepare your clients for mediation?
There's a couple things. First of all, is I don't like mediations before litigation, but that's me liking litigation and feeling comfortable there. So what I do is I'll agree that we will exchange the basic federal rules of court discovery in advance of mediation, so we have some documents, because defendants have all the documents, we don't, unless our client is taken them illegally, or recorded conversations they shouldn't have.
That never happened. I don't know what you're talking about.
Every day. Or we just don't often have as much information as the defense does. So in order for us to have mediation that I think is impactful, I want to exchange some discovery. We'll agree to limited depositions on each side. I'll say you can take my client for 4 hours, and I'll take 2 of your clients for 2 hours, and then we'll at least come in with some information so we can settle the case if it's going to be settled. But for preparation of my client, I tell them to talk to a tax consultant, because the taxes and employment cases are difficult. I tell them that they need to have whomever is important to them in making decisions available. I give them an Excel sheet of, if the case were to settle, here's the ranges, go over the goods and bads of the cases and why it should settle or shouldn't settle. And then if it's a big enough case, I'll send them to experts regarding an economist and emotional distress. And one thing for sexual assault cases that I've been looking a lot more towards is that I think severe PTSD changes the mind, just like traumatic brain injury. And so we're going to be looking at working with neuropsych. So if we need to have a neuropsych involved, I prepare for that.
So I think Maria's right, and I think that frankly, the preparation for mediation, if you do it right, you set the tone and the stage to resolve your case. And it's almost more important than whatever you do at the mediation. And so a lot of the things that I'm doing are with my client. And so I think that it's important that there are no surprises on my end. And we'll talk a little bit more about during the mediation how to control that. But for instance, I need to make sure that I have an analysis prepared in writing, ideally 30 to 60 days before the mediation. So when I prepare and this is for both private clients as well as those that I'm tapped in with an insurance panel assignment. And so I want to make sure that everybody knows the state of affairs 30 to 60 days. And we'll talk a bit about why that's important. I also want to make sure that they have fees to date and my litigation budget through trial. They need to see this and know it, appreciate it, digest it. I want to make sure that all the right decision makers are not only apprised of the case, but available. Now, this is one of the both the pros and cons of Zoom, is particularly when you've got your C-suite is in New York or the insurance adjuster is in Connecticut, it is a pain to get them to California. So Zoom has allowed actually a broader availability of decision makers to attend the mediation. However, I always feel like I get half of them because they're doing other things. They're not committed to the idea. If you fly a professional out, it's a 3-day commitment to fly from the East Coast here to land overnight, spend the night, just make the mediation, and they're not flying home on a red eye, so they're minutes to file the next day. So there's a certain commitment, but getting decision makers, making sure that they are advised is important. And then finally, again, we haven't talked about the case itself, but making sure that if there are coverage disputes between the insurance carrier and your client, you want to have those handled between them. It's not a decision that we get involved in, but you need to tee them up and present it so that they can resolve them, so you're not having 2 mediations going on during your day off.
Thank you, Joe. From a mediator's perspective, prior client preparation can be essential. The fastest way to end a mediation unsuccessfully is for somebody to leave. There is no way to negotiate past that. And if counsel have not expressed that to clients and let them know we need to leave the entire day open, or maybe even into the evening, and people have to leave to catch a flight or for a previous commitment, you're done for the day. It doesn't mean you can't come back. For that day, you're just done. So preparation of time and facilities, like Joseph said, having the right people, essential. Also, if there's been a big number in the complaint, and the clients have heard a big number, it is so valuable when the parties show up for mediation, if the counsel have prepared their clients as to what the reasonable expectations are to receive, not at a jury trial, not after a successful, shoot the moon, win in a disputed proceeding, but a settlement. If they prepare them appropriately, you're going to increase your chance for settlement. Now, having said that, it's a somewhat common experience for attorneys to have client control difficulties with what the expectations are going to be. And it's a very interesting dynamic. I experienced this as an attorney when I was mediating years ago, and I still experience it today, but on the other side of the mediator. This happened just this last week. Sometimes clients will come in, they'll have very unrealistic expectations. As a mediator, I start saying, well, you know, you've got this and this, and you thought about that, and I'm sort of trying to talk reason into them. And then the attorney will jump in and I'll say, well, what Mr. Jacobs is saying, and then he'll start, and what it starts to feel like is frankly, you're double teaming the client. You know? And if you have an attorney that you have a good connection with, and you can do that together without offending the client, without disrespecting them, addressing their needs, but then sort of talking to them, you end up working together trying to say, here's the reasonable expectations and literally what I can get today. A lot of that hopefully can be done if the client and the attorney have a good working relationship in advance of the mediation. Where it can't, then you end up doing mediation.
I think another important thing is timing for, like sitting down 998s, and for plaintiff's fee hawk cases, there's no reason not to. It's extra 10%. Unless your case is the worst case and you're a total liar, you're not going to really have many ramifications for not sending down a 998. And if you go to mediation and you have a 998 that's outstanding, mediator almost always wants you to negotiate on the 998. I intentionally make my 998s the bottom dollar that we'll accept, because I want to beat the 998 at trial and make more money. So having, the appropriate timing of going after the 998 is expired, so then it's like, look, it's expired, we have more attorney's fees, the value of our case is worth more, and also we send out policy limit demands for a lot of cases, and making sure that we go after that's expired, because we don't want to be negotiating from those numbers.
So question for Joseph and Maria, do you bring a fully prepared final form of settlement agreement with you typically when you show up at mediation?
I asked defense counsel to send it because I get paid by the hour.
I'm more than happy to prepare one. So, no, we as a practice in my office prepare the settlement agreement and have it approved on our end from both the advocate carrier, the client, and whoever's going to be signing it needs to sign off on the general terms. And then I send that over to plaintiff's counsel at least a week in advance. And I started doing that years ago because I got sick of the 6 p.m. We've got a deal. Now let's start talking about whether confidentiality or rehire back in those days, or tax allocation, and all of a sudden it's midnight. And I'd like to get ink on the deal, because there's nothing worse than either the Monday morning quarterback or the everyone getting cold feet after the effect. And that's just as likely, imagine, for the plaintiff as it is for my client when they go back and report to their boss and their boss's boss, and they go, why the hell did you settle for so much? If ink's on the paper, it makes my life easier. I'm sure it's the same for you. And so I wanted to smooth over when we are just negotiating the dollars and cents. And so if I get that to you a week in advance, one, most good attorneys will respond and say, here are my sticking points, let's figure those out. And you also have the ability to talk to your client in advance. I see what's happening. And for those who don't, I now have the moral high ground to say, I gave it to you a week in advance. I've been negotiating as though these terms are part of the deal because they were in my draft agreement. I'm going to assume that they're there. Instead of what I've had is the plaintiff's counsel nickel and dime me and say, well, you want a 1542 general release? No, we were just talking about a single, just the claims in the lawsuit. That'll cost you more. And I can't do that at 7 p.m. anymore. And so by putting forth my expectations up front, it smooths over the deal. And then at 6 o'clock, when we get the number done, by 6:20, we've got dry ink and we're going home. So that's my impression. And again, I've been burned by a few folks that treat it a little more haphazardly. That's why I've done this. I don't know how you feel about the exchanging that or.
Yeah, I mean, the sticking points for the terms are always the same ones.
Mm-hmm.
So there's no reason not to negotiate them in advance, whether your case settles or not.
Right. And the only other piece, I've had defense counsel tell me that I'm silly to do this because I'm sending the message that I'm willing to settle. And it creates this expectation. I'm going to mediation. I'm already here, and we're just talking about the dollars and cents. And so I don't think I'm giving away anything by circulating this. And for those who work with me over and over and over again, the plaintiff's counsels know that my firm always circulates a settlement agreement. So it gives away absolutely nothing.
takes a very secure attorney to do that, so you've exemplified that.
Well, and that was going to be my point on this. Exactly what you said. When I'm in a mediation session and I ask early on, do you guys have a draft settlement agreement from either side? The response is, we don't want to give away that we're willing to settle. We don't want to tell them. Agreed. Agreed. I'm not going to say it that way, but agreed. It doesn't give away anything, at least from my perspective as a mediator. It's trying to negotiate those terms in advance, the sticking points, to avoid what you said, Joe, the 6 o'clock we got a number, and then you're there till midnight hammering down.
And Maria, have you ever gotten a settlement agreement draft and gone, jackpot, we're gonna get this thing done? No, you've done, that's the easiest part.
Yeah.
There's no numbers written in it.
I routinely invite counsel to bring with them a fully formed settlement agreement, so that if we have agreement that day, you don't have a lot of delay, or you can't get it done, and then you have things move sideways the next day. Some counsel take me up on that, some do not. I had a case right now that was done 6 months ago, mediated, settled, agreed, done. It's still not done because there was one term that wasn't talked about. It didn't seem to be important at the time, and they can't get agreement. It's been 6 months. And so if people will bring, the nice thing about having a fully formed settlement agreement, instead of doing a term sheet, is you make sure you're addressing all of the terms, and there's not something left that hasn't been addressed that then becomes a sticking point later on, or you don't get the Monday morning quarterback, people waking up the next day saying, you know, what was I thinking, or talking to somebody else. So I always recommend it, but you can't always get it.
I had a case 15 years ago that still sits with me, and it was exactly your situation. I'm so mad about it. And it was, my client agreed to a deal. We had an MOU, but not a fully formed, long-form agreement. And in the morning, they went, we can do better. I want you to negotiate from the MOU, to which we said, that's not how this works, and it tied it up for 6 months. The litigation machine was turned back on because the deal fell through, and I'm so mad about it.
You know, you tell people these stories and they don't believe it, but it's true.
So let's move on to what I think, as a mediator, is one of the most important aspects of the pre-mediation timeline, briefs. And I want to ask, let's start with Bob on this one. How important are pre-mediation briefs?
It depends on the case. Depends on the case. But I had a case, you know, the briefs and the exhibits, I always ask for briefs and I ask for key exhibits. So here's an example. I mean, I've done some real estate cases that have breach of contract claims. That's the whole genesis of the case. And I asked for the exhibits. And when I've gone through the exhibits, I've looked through there and I've seen a contingency that's not been released. Neither side had picked up on it. Now, that's not going to be every case. But as a mediator, if I get a brief and it really details the facts, and it's very careful on the law, and if it's got the key exhibits, then I'm able to give a separate kind of review on it. And sometimes there's arguments that come up. As a mediator, my mantra is do no harm. So if there's an argument that's really going to benefit one party, if the case does not settle, I cannot discuss that point with the party is going to benefit. You can bet I'm going to be in the other room talking about the other side, saying the other side hasn't raised this issue. By trial, if they see this and raise this, do you really want to be trying this case on that? And sometimes that'll be dispositive on the case. So I ask for very thorough briefs, and I ask for them, I don't know anybody else that does this, I ask for briefs 2 weeks before the mediation. I ask for way in advance, and I can't always get it, and when I can't, then I deal with what I can get. But if I can get them 2 weeks in advance, then what I do is I do a pre-mediation conference in advance, and I read the briefs as soon as I can, and it's surprising how many times there is some preparation, or some additional workup, or some additional something that people then have time to do to really be prepared for the mediation, that if you get them just 2 or 3 days before, there's no time to do it. So I get it when I can.
Sure.
What do you do when you see they both miss the issue?
I've had several of those cases. When I see they both miss the issue, then what I'll do is I will not say anything to the party that is going to favor, because that would tip the balance in their favor if it goes forward in litigation. That's not my job. But if the side that's really going to harm, I'll go in and I'll say, look, you've got this issue here. I don't see it addressed in the briefs. The other side hasn't picked up on it, but that doesn't mean they won't, or that doesn't mean that Judge sua sponte at trial won't come up with that you really want to litigate this case based on that. And especially if it's a dispositive issue, like a unreleased contingency, those cases settle very quickly. The other side can never understand why. They think you're some great magician. Oh my gosh, you pulled this rabbit out of the hat. How'd you do this? They decided it's on transit. Well, it just worked that way, you know.
And sometimes, to this exact point, sometimes a lot of mediators come in and go, I know this is a sexual harassment case, and again, I'm just doing employment cases. Have you considered there's a pretty clear-cut age discrimination issue that nobody talks about? Now, I've probably flagged it for my client, but I'm not going to bring it up. I'm not going to tell the mediator gratuitously that I see an issue the other side hasn't queued up to. But having them tell me, and then I can poo-poo it in front of the mediator, and then when they leave the room, I can go, see, I told you, this is a reason to get rid of this case, because the age discrimination case is the real dragon in this one. It's not actually going to be the sex harassment case. So I'm always in favor of the mediator doing some issue spotting. Now, that is different, though. I talk about how important it is for me to brief the case, to get my client's assessment, to get their valuation, to have them come with authority, all those things. What I cannot have happen, though, is the mediator come in and do the opposite and say, they are making a new legal theory. They haven't mentioned ever that there's an age discrimination case before today. Turns out their whole case. They're pivoting away. Now you have to respond to a new claim. No. The answer is no, because I like to be prepared. My clients need to be prepared, and like a tanker ship, it takes a while for me to turn. I have to get authority. The person I came may have only brought $100,000 for them because that's more than enough. And now we need 200. It can't magic overnight. So when we talk about preparing, a lot of this is to get enough information so that there are no surprises in mediation. It's the same for the mediator. I talked about what my brief looks like, but this is a big one for me that I cannot change on a dime. And so it's important that in this case, the plaintiff's counsels tell me 2 weeks in advance, hey, new theory, just discovered it. Turns out there's an age claim you haven't looked at. We're going to be talking about that in mediation. We need to move the date, or are you comfortable keeping it? And I may say, hey, I'm not prepared to mediate in 2 weeks. We got to move the date. And that's acceptable. And most mediators will happily change the date because they don't want to waste their time if there's no value in getting the date done. And most of them can fill it anyway.
Yeah. Well, I mean, for me, it depends on where the case is and the complexity of the case. If it's a really simple case where it's clear liability, it's, you know, this is who the person is, here are the damages, see attached text message. If it's a really complex case with a difficult legal issue, then it's got to be a more complex brief. But yeah, I definitely prepare it, I exchange it. I think it's, as a plaintiff, it's pointless not to exchange because you're asking for money. You want to do it so convincingly, because I like to ask for a lot of money. So I want to really show that this case is worth a bunch of money, and here's all my evidence as to why.
Maria is exactly right. And to see it from the other side of the room, if she doesn't tell me why I should pay more money, I'm going to tell my client they shouldn't. And so we are aligned in some fashion when she provides declarations. When good counsel give me signed declarations, give me their evidence and text messages, give me their expert report, I can look at it and, to use the parlance of my friend here in the front row, oh shit. Right? This is what you want, is for me to have that moment, because I'm going to advise my client that this is something they need to get rid of before trial. But if you hide your brief and keep it closed, then I only have my narrative. I've seen your complaint. I know what you're going to say. But I haven't seen any of the support, and everyone I've interviewed has said X, Y, and Z that's consistent with my defense narrative. So when I talk about what I do for my briefs, I just set the stage. I don't do much legal advocacy. I hire folks who know the labor employment world. David doesn't need me to cite him chapter and verse of basic labor employment law. Maria isn't going to be moved by my legal analysis. Instead, it's just, here are the facts, and I present them as a chronology, and every bullet of the chronology has the supporting evidence attached as an exhibit. So my brief is very, very short. I strive to never have them more than 8 to 10 pages, ever. But I will, my compendium of exhibits will carry the day if you want to reference them. And it's everything from start dates to dates of the complaint to the adverse employment action. It's all there. And so that way, when the mediator looks at it, nothing I say is unsubstantiated. And they can then support that if they have to go in the other room and sell the factual dispute. Because that's what we're arguing about. It's rarely the law.
Well, and to that point, mediation at its basic form is giving people information to make a decision on whether or not to resolve the case or proceed further into litigation. Exchanging briefs is the first step in that information exchange. And without it, I personally feel that the entire mediation would be hamstrung because it, A, shows a lack of trust in your opposing counsel. B, it could signal that you're not actually fully prepared. And C, you're trying to hide the ball on something. And as Ray was saying, there's no need from the plaintiff's perspective. When I was litigating, our goal was to prove our case. And to do that, despite the occasional time when I didn't, Joe, sorry, we would exchange briefs. And it made things so much easier.
So thank you. To speak to that, there's really three kinds of cases when you come to mediation. There's the case that is poised to settle and no one has telegraphed that to the other side. And as a mediator, you'd say almost nothing or very little, and it really doesn't matter much, and the case is just begging to be settled, and it collapses and it settles, and it doesn't really matter which is done, it's just there. Very, very ripe for settlement. That's one kind of case. On the opposite end of the spectrum, you have the case that it doesn't matter what you say, or what anybody says, that case is not going to settle. I had one of those last week as well. I could not get an offer. I had one last week, I couldn't get an offer from the plaintiff. Another one, I couldn't get a dollar from the defendant. It doesn't matter what's going to be said, it was done. I arm wrestled as hard as I could. In the middle, that's where the magic happens. That's where the cases can really go either way. And to my mind, the highest level, and it's not the highest level because there's so many complex factors that go into being an effective mediator and doing effective mediation. But one of the highest level considerations for a super effective mediation is where the mediator goes into the other room and they are making your case, where they make your closing argument to the other side. And so that has to do with the title of this program, Stocking the Armory. If you equip your mediator, so first of all, it's in selecting the mediator. If you choose a mediator who is going to do that, and not every mediator will, but if you choose a mediator who's going to make your case to the other side, and they're going to do it effectively, and that's also your evaluation on choosing the mediator, then the thing you want to do in that mediation is equip that mediator with all the tools and as much ammunition as they have to go in and in the nicest possible way without trying to berate somebody or push somebody to make your best case to the other side so they can change hearts and minds. That's the real, where mediation really, the rubber hits the road. If you put a brief together and you say, I'm just sending it to the mediator, what good does that do? All you do is persuade the mediator. And as a mediator, if I receive a brief that's not been shared with the other side, I don't know how much of that I can share with the other side, which means I now have to go, and on every point, I have to get permission to share, and everything just craters as far as time, and time is precious. Because if it's a hard-fought mediation, you may end up at the end of the day, and you may need all that extra time that you have. On the other hand, if you give your brief to the other side and they know exactly where you're at, we all have a level playing field, we know what the issues are, then the mediator can go to town and start making your case in the other room. So I always recommend that parties always share their briefs, and if there's something you cannot share with the other side that you have to hold back because you have to present it at trial, you're going to ambush the other side, or you have to present it at deposition, and you can't let them be prepared, then do a separate confidential brief to the mediator on that point and give everything else to the other side so we can get to it and see if we can get this case settled, because time is just truly, truly precious in these proceedings.
As a practical tip for mediation briefs, what I do, and I don't exchange this with defense counsel, is I do an executive summary. And everybody naturally, if number one is important, it's the most important thing in my executive summary is my best piece of evidence. And I have a chronology with citations to all the evidence. And for all the depositions I take, I have one exhibit folder, and I start with 1 through 10 as my best pieces of evidence, and for the same exhibit in every single deposition, and same exhibit in my mediation briefs. And it's just to make it easier also to show, like, here's the top evidence, and here's how to find it real quick.
I mean, having it on demand, there's nothing worse than saying, I'm pretty sure somebody said something in a demo, and having to look it up. If you just have it, it's black and white, you've got it. We all have technology that can reference these things immediately. I mean, one of the things I was gonna talk about, we talk about what's in our brief, but what do we wanna see in other sides of the brief? I talk a little bit about how you need to give me enough information that I can make my assessments. But things that are important for me to see in the plaintiff's brief to be effective is one, avoid bombast, right? Assume that this is gonna be shared with my client. The moment you call them a dirty so-and-so, they've stopped reading. They stop caring. And so I write my briefs, even the ones that I don't share with plaintiff's counsel, that I'm gonna give my private brief to the mediator, I never include incendiary language because it is counterproductive. We'll talk about that in joint sessions. I do not think there is any value in name calling, gross mischaracterizations, and that. And I know there's a temptation to do it, but it is not effective. It is counterproductive. The other thing is support what you do. So if there is someone's going to say something, ideally it's a declaration, but at a minimum, you have to tell me who. And so if somebody's going to support the plaintiff's narrative, you can't say an anonymous coworker is going to support this narrative. I cannot value it, I give it 0 weight. If instead you say that Jane and Bob are going to support this, I'm going to confirm, I'm going to call Jane and Bob, so why it's important you give me the brief more than the night before. And if Jane and Bob confirm it, your settlement value went up. If Jane and Bob reject it, I can then present to you and your expectations go down. It's all about having access to facts, and this idea of holding back is rarely effective unless you need it for some sort of gotcha moment down the line with depositions, for instance. But then if I have one of those, I know that you can't value it. I can't just hint that I've got something and hope that you're going to believe me. It doesn't work that way. So I need as much information and ammunition in both directions as possible if we're going to try to get this thing done.
I had a mediation last week, where I got a mediation brief, and the first sentence said, "This is a stupid case brought by a stupid attorney for a stupid purpose." And it went down from there. It was a very lengthy brief, and there's a lot of information the other side needed to see, and it was going to take me forever to go piece by piece. So to Joseph's point, I called the attorney up, I said, "Help me help you. Please redo your brief, take out every insult," and there's other stuff in there that I don't want to talk about. I said, "Take it all out, make it so it's going to be readable, and then send it to the other side right now, please." And he did that, and it was helpful. But to Joseph's point, I mean, finally, in this mediation, I was doing it yesterday, he said, and so he took out all the really incendiary stuff, inflammatory stuff, but then he was still saying, she's a liar, she's got no integrity. And so he called me on the carpet. After about an hour, he said, "Has she read my brief?" I said, "I don't know." He said, "Please ask her if she has read my brief." And I said, "Look, you know what's in that brief. This is the very person that you're asking to discount what they're asking for, the money they're asking for. Do you really want to force me to ask her if she's read your brief or to encourage her to do it if you're going to be saying that?" At that point, he backed those and said, "Leave your judgment." I said, "My judgment is, no, don't force me to go ahead and read your brief. The attorney's read it, that's what needs to happen. Let's not inflame the client anymore." I think sometimes because attorneys feel deeply about their cases, and they take it personally, even in business context, even in insurance context, attorneys take it deeply. And because we feel deeply, sometimes when we see perceived wrongs or inequities, it's easy to let it come out in the language. And when that happens, it's easy to lose sight of the person who has done the wrong is the very person that you need to move. So to Joseph's point, inflammatory language, it does nothing to help me into the room, and I just have to spend a bunch of time trying to spin people down. And once people get their backs up, honestly, when people get their backs up emotionally, reason goes out the door. And then I start getting comments like, "You're not acting rationally." I'm going, "What did you expect? You know, you just impugn their integrity and everybody they are. Why would they not act rationally?" And they don't. So anything you can do to not inflame people is a big plus.
I mean, when I have my clients read the briefs, and if a defense counsel sends me a brief saying, "Look, this was a good person, they worked here for 30 years, they did something that we reasonably believe is wrong, and got rid of them." And don't make it personal, my client is so much more likely to say, "Oh, I can see it from their perspective," versus they were a horrible employee for 30 years, they're lousy, they're still a scumbag, and should have fired him earlier.
You know, right? Sometimes they feel that way, and that's how they feel after they got sued. And there's this temptation from the defense side to justify why they're gone 10 times over. No, you fire them because of this one thing. So one of the questions I have for you, Maria, is credibility assessments are pretty big in my work because it's often he said, she said. And so we do parade quite a bit of here are the things they misrepresented. Everything from their resume is inaccurate to here are the things that you say in your complaint that we can dispositively prove are different. Is that effective? And if it's so, is it for you or for your client?
I mean, the resume stuff, I think, is a huge waste of time. It's like you hired them, and most of my clients worked there for, 20 years or whatever, and you're looking back at what they put on their LinkedIn 20 years ago. I just gotta brush it off. But, I don't know, what else? Some of that stuff helps, if you're gonna tell me something about my client, I work on contingency, I wanna have a case that has value, and if it's something that really devalues the case, I take it seriously, and I'll say, look, this is bad.
Just to follow up, and thank you for that. Sometimes I have people ask me, how important is it to cite the law in the brief? If you're a mediator and you're evaluating your mediator and opposing counsel, and if all three of you are in this area of the law all the time and the law hasn't changed, then you don't need to cite a whole lot of the law just because it's a brief. But on the other hand, I had an attorney yesterday telling me that that the failure to list a property in the bankruptcy schedule means that that person can no longer ever make any claim to title to that property. And I said, cite me the law, chapter and verse, right now. If you are right, that's a dynamite point, I need the law. And so I called them out on it. I didn't think that was right, but I wanted to see it. And they came back and they gave me a generalized statement. I said, no, I need something specific to bankruptcy. They couldn't come up with it. If there's a key legal point in a brief, and it looks like the case turns on it, or it's something that I will use in the other room, I will read the case. I'll read as much of the case as I need to. People are paying me by the hour to prepare, so I'm not going to spend a lot of time reading a bunch of law. But if there's something that's critical, it's valuable to let the other side know it and to let me know it, and I'll read it. And if you're in employment and that's all you do and everybody knows it, then it becomes less important. But I deal in a lot of different areas. And the thing is, unless you're using mediators and you know their background, you don't know how well they know the law. And so how much do they need to be equipped to do that? You have to make a decision how much law you're going to cite the brief, but I rely on it. Absolutely.
Well, to that point, going back to the mediator selection, if you're considering using a new mediator that you've never used before, call them. Call the mediator. Have a conversation with them. Learn about them. See what they know. See what areas their litigation practice was in. And that will give you the information on whether or not you need to include more law, less law, just the nuances. But I think people are afraid to get on the phone and make a phone call to someone they don't know. And I know I did this as a litigator. Whenever I got into opposing counsel, I think I did this with you, Joe, a couple years ago, whenever it was my last case. Call them up and just introduce myself. Don't talk about a case, but it's a way to get off on the right track with someone, to learn about them, learn about their history, to learn about who they are. And I feel like that art of conversation has been lost today. And it would be so much more helpful if people did that.
Well, talking about this pre-mediation conference, let's move on to beyond the brief. We can always come back to that, but I think a pre-mediation conference is imperative. I always call the mediator, and ideally I do it at least 3 days in advance. So, unlike Bob, most of my mediators don't require the brief more than a week in advance. I hit that deadline, and it's not because I didn't need a week to read it. I think it's because they have 3 mediations a week. They've set aside a certain time to look at my brief, and if I cut them down to the wire, what does that mean? It means they're going to give my brief less attention. They're going to have less time to prepare, and then when I have that conversation, I want to seed the ground for my case and for resolution. So that conversation I have is multifaceted. One is, what law do you need? Is there something that some specific issue, to Bob's point, that I didn't address? Then I say, am I missing anything, right? Hopefully plaintiff's counsel sent me the brief, and I already know what their case is going to be. But I want to know if I'm going to walk into a buzzsaw. And if there's something, hey, you should really look at their supporting evidence, their witness statements. I think that's where the case is going to come down. Great. Now I'm going to go and I'm going to talk to all those people. I've got 3 days to go conduct a series of interviews to make the day more productive. Either it's going to confirm the plaintiff's case or it's going to get rebuttal. But at least I'm going to come prepared, because there is nothing worse than being in a mediation and being either blindsided or appearing unprepared in front of your own client. So a lot of this is self-preservation. You want to look good. And so by having this phone call, you can get the important information up front.
Absolutely.
If I may, on
Go
the
ahead, David.
importance of the pre-mediation call, one of the reasons I use the call, and I try to have these pre-mediation calls in every case, is to talk to the attorney specifically about their client and maybe gain some insights that I wouldn't get with that attorney at the mediation in front of their client. I found that people tend to be more open in those pre-mediation conferences to tell me, what points to hit, what points to kind of lay down on a little bit, and where to hammer, where not. That's part two. Is I want to know if there are any substantive or emotional barriers to settlement that I'm going to need to get through, and how best to get through those. We don't talk about the case all that much. I'll do, Joe, you were saying, give you my take on what evidence might be necessary to supplement the brief, where the key points are, what the key claims are, and so that you have those 3 or 4 days or however long it is to gather that evidence to give to the other side. But it's mostly about the clients and trying to figure out more about them and learn who they are through their attorneys.
I use it a lot with clients that, in addition, because I've asked for briefs well in advance so that I can have this pre-mediation conference and have digested the briefs first. It's surprising to me, notwithstanding the best intentions, attorneys are busy. And you can't always get your case fully prepared in advance. And so when we get to that pre-mediation conference, it's a structure for me to read the briefs, it's a structure for me to look at the conference, it's a structure to engage with counsel, and we have received the other side's brief if they've been doing their homework, so we know what the issues are. And many times there's a factual issue that hasn't been fully fleshed out yet. By holding those conferences more than just 1 or 2 days beforehand, it gives us some bandwidth and some runway to get things teed up. If there's something else that needs to be done, something else needs to be acquired, someone else that needs to be talked to, we have time to do that. And that happens in a surprising number of cases, which only maximizes it increases the likelihood of settlement if we're fully prepared.
For this pre-mediation conference, a lot of what mediations are is you need to make mediation in general. What's the number one role of mediation? Is when I select mediator, they need to make me look good. And my job is to make my client look good to their boss and their boss's boss. And so I do that, again, by being prepared. I do that by setting expectations. I do that by bringing the right people. And then there's going to be a lot of effusive praise for the good work that they did in preparing the case, right? And they know where they screwed up. But when I do the pre-mediation conference, I'll typically tell the mediator some of the personalities that are involved and give them the tools they need to be able to settle. So for instance, the case I had last week, the gentleman who was coming, he's the president of the company. He's 25 years old. He is the son of the true owners that founded this company 40 years ago, and they just passed it down to him. And I let the mediator know, this kid needs to look good to mom and dad. He needs to show that he has control, that he did everything right, that this either happened not on his watch or it was completely reasonable how he responded. He's willing to pay to get it done, but you have to make him look good to mom and dad. And that kind of thing, I can't say that. You can't say it in front of them. And I'll deny it if you ever. But that's what the pre-mediation conference is for. Then the mediator came and made the kid look like an all-star. And he got to go home to mom and dad who were looking over his shoulder and say, what a good job he did in handling this litigation. So that's the kind of thing the pre-mediation conference is gold for, setting the table.
And that ties in. What that means is that Joseph had the right mediator who was keyed into essential non-monetary considerations. And non-monetary considerations many times are where people get their backs up. This wasn't where somebody got their back up, but it was still critical for this client's perspective. So when you're selecting your mediators, if you have non-monetary considerations, whether it's this or anything else, clients are going to get out of shape, they get hot under the collar, whatever, or have very wounded perspective, they've been hurt. If you can get a mediator that is agile, it can come in and read the room and read clients and talk with counsel and understand those very critical non-monetary considerations, you just set yourself up so much more for a positive experience, both with resolution as well as weighted as hand. Very important on mediator selection.
We haven't heard from Maria on the pre-mediation conference.
I think it's great. I find it super helpful, especially because my clients are hurt. In the United States, everybody associates their job a lot with their identity. You take that away from them and call them a liar and a cheat and a thief, they're not going to be in a happy place typically. And so having that call, trying to explain to them where the client is coming from, how to handle them, and what best to talk about or not talk about during the mediation is very helpful.
I think we're ready to move forward to the actual mediation session.
Let's get there.
Let's get there. Let's start with one of the, it used to be kind of an old school question. We don't see it so much anymore. Joint session. Preference for joint session, either beginning, end, not at all.
Hard no.
I like it because I like to convince people to have a good case, and it gives me an opportunity to present the case to the other side and say, look, here's why I'm going to win, and I want your client to hear it from me.
See, the problem I have is in order.
It's a bed tone.
No, you're right. I think it really entrenches the parties, because what I'm gonna have to do is to go up, and part of my case is credibility of the plaintiff. I'm going to have to undermine that credibility. And so Maria talks about, all of these people don't like being called liars and cheats. Sometimes I can do so strategically, but if I do it in a joint session, I don't think it's terribly effective. And then similarly, if the plaintiff's counsel is saying, that person right there created a culture of harassment, or discrimination, or profits over people, all of a sudden hackles are up, and I have to spend the next 2 hours of the day bringing people back to the baseline that I brought them at. So I find it's terribly unproductive. And then if it's a wage and hour case where there are no emotions, did meal periods happen or not, it's in my brief. I don't need to go up there and hear myself talk or hear the plaintiff. And by the way, if we could have just talked to each other, David and I settled cases by calling each other on the phone, because we knew how to navigate through this. We didn't need a mediator at all.
And we also knew each other by then and trusted, again, it goes back to trust. He wasn't going to, BS me on that. But yeah, it worked flawlessly. That was my last case.
The last case, you didn't even have to litigate it. You just.
I wanted to, though.
We had to. That's why I gave you so much money. But I do think a joint session can be counterproductive. There are some times when I'll do it, and Ray and I talked about this morning, sometimes the value of an apology. And I have had cases in which my client has wanted to go up under the protection of the mediation privilege and say, we screwed up. We value you as an employee and part of the ABC co-family. We screwed up on this one. We're really sorry that it went this way. Holy cow, I can talk about letting a lot of the air out of the process. And that way they can save face, it's not admissible for any purpose, and yet it sets the tone for the day, and everyone sort of comes down. But if it's gonna be all arrows and barbs, I see no reason for it.
Let me ask a quick question, follow up on this. What about a session of just the attorneys to give that perspective?
I've already done it. To me, it seems unnecessary, because I already talked to the plaintiff's counsel so often that there's not a whole lot of.
In the past, I do bigger business cases, so it's professionals on either side. I've had the mediator pull the two clients and take the attorneys out of it, because sometimes the attorney's the problem. Your kind of cases, that doesn't work. I don't know if the mediators have seen that in some their cases where it's the attorney's the issue, it's not necessarily the clients are blocking the settlement.
That's the big exception. I have done that, but it's the big exception, because the attorney's going, wait a minute, I'm not in the equation, so it's not, the attorneys have to definitely be on board, but it can be done. Yeah, I've done it.
I've done it with C-suite. I've seen it done in employment cases when you've got a C-suite executive on both sides. You've got someone who's a CFO who's done it for 20 years suing their prior employer. We've got intelligent folks where they can talk. But I think that the power discrepancy dynamic doesn't allow most employment cases to play that way.
I find bit concerning on the plaintiff side, where I see burning policy limits. And I see defense counsel working up a case in a way that's like, wow, you should really be settling this case, because I know my client has $100,000 in economic damages, no medical treatment whatsoever, yet you're litigating this case like it's a $10 million case, and it's not, and you should be paying out the policy. And so there's times where I think I need to go over the attorney's head in some way or another to figure out who's making the decisions, because it's not making sense to me.
When I do these, I typically, right at the very beginning of mediation, I ask, or in pre-mediation conference, I ask both counsel, do you see any value or need or use for a joint session? I ask counsel, and if they both do, we do it. If one side does, one side doesn't, we don't do it. If during the mediation I see a need for it, then I might do it. One of my favorite cases, years ago, I had a construction defect case, and as we got underway in the mediation, it became apparent that it hadn't fully been worked up. And I asked one party, what does your expert have to say? Well, I don't know. Let me talk to him, They got on the phone, and I'm going, can he get out there? Can you bring him here today? And they said, yeah, I can. I said, great. I went and told the other side. They said, well, then we want our expert here. Was he around? I don't know. They said. So they called him. I said, okay. So we took a break for an hour. 2 experts came out with very expert-intensive questions, and the case just hadn't been worked up yet. And it was really fun because we sat there in the deposition and both attorneys were agreeable and the experts cross-examined each other. It was a blast. They just sat there and both went back and forth, and all the attorneys and the mediator sat there and listened. Very unusual, but very effective. So you have to really look at the situation, what's needed, and if it looks like there's a joint session that's going to be valuable for whatever reason, then you talk about it successfully after. Anything else in joint session? How about the mediator speaking directly to your client? Some attorneys don't like that. Not separately without the attorney, but just in mediation caucus breakout. Is that a good idea? Are you comfortable with that? What's your take on that? As opposed to addressing everything through counsel.
I prepare my client for it. I say the mediator's going to want to evaluate you as a witness and, get their opinion of it. And then I prepare them and say, here's a couple questions mediators typically ask. Let's go through it and see what you answer. And I like it, then I'll let them talk. And if I don't, I won't.
And so it's interesting. So I have the same issue, and sometimes in the pre-mediation call, I will tell the mediator, don't talk to my client. And it's usually because I know they can't handle it, or they're going to want to expound, and they'll filibuster their own mediation. They'll just talk and talk and talk and talk, and I don't want to waste the time. And it's easier for me simply to say, please don't talk to them. Credibility assessments, I'll tell you the good, the bad, the ugly. Question I have is what happens when you've got a non-native English speaker in the plaintiff's room and the mediator doesn't speak Spanish? What happens in terms of building any rapport or any communication? Do you bring a translator, or do you just say they're not going to speak today? I've got it.
I want a mediator that speaks Spanish.
Yeah, I would mediate with someone who didn't speak the language of the client. I would mediate with someone who didn't speak the language of the client. We have a lot of Spanish-speaking clients, some Mandarin-speaking clients. We get mediators that speak that language.
I typically try to. So, for instance, Vivian Williamson is a Spanish speaker. I know that she can communicate with the plaintiff. Other times I've had plaintiff's counsel who more or less won't select somebody. They intentionally build that wall, which I think is because they want to be able to control, talk about who's in charge. They want to have the ultimate control of the day, and if the mediator cannot even relay an offer, then you can't. I think it's ineffective.
I think it's concerning.
From my perspective, I'm talking about Spanish speaker. I know when people look at me, they say, "Oh, he's a Spanish speaker," clearly. But I do speak Spanish, and I can't tell you the rapport that it does help build in the room with those Spanish speaking clients, even if their English is perfect. But talking in their native language tends to just build that rapport. So, and selecting a mediator who does speak that language is important for that reason.
Talking about speaking the language, sometimes it's more than just the tongue. It really can be who speaks the business language. And so, for instance, if I'm representing a winery, if I can find someone, a mediator who has worked in the viticulture industry, that carries so much weight because they now speak the language. They understand what the industry is going through right now, which is a massive recession. They can understand about the seasonal nature of the work. They understand all of the little pieces. And so talking about building rapport, sometimes it's not just about income, it's about understanding the client's business more than being a judge.
Well, and I think with selecting the mediator, it's hard to find people that are mediators that have a lower socioeconomic background. And I think that that's important for my clients because then they can relate to that person versus just sitting in front of a judge or somebody that's been a rich attorney all their life and now they decided to make a bunch of money off of mediation. And so if I could find somebody that has a diverse background, I think that's really helpful for my clients to relate to them.
Does it make much, or do you select based on whether they were or weren't a judge? Because I find in some cases, I want that judicial robe. If you would come into my court, this is what might happen, at least for my own client.
Depends for, yes, the answer is yes, and I decide if the case requires an evaluative process where someone's going to say, listen, on an MIL, that's never coming in. I mean, that piece of information, yeah, while bombastic and amazing, is never gonna see the light of day. And that's important. Or their mediation proposal, there's one mediator I use who issues a sort of written summary of findings in connection with their proposal. Here's what I think will happen at trial. And I pick them on cases in which I like that, either because I think my client needs to hear it, or because I think the other side needs to hear it, but it comes part and parcel. But most folks don't need the judge. I actually find the smaller business, the person who founded their own bakery that has 10 employees, they respect someone who was a judge so much more that it's more effective for me and that they'll respect what they have to say. I don't know if you have that say.
Yeah, it just depends for the case. So there's some cases with complicated legal issues or complicated issues for trial that I think the judge is helpful for, and there's some cases it doesn't.
Let me ask another question, separate related topic. When you're in a mediation session, and the mediators come in and discuss some considerations with you, do you tend to discuss the case with your client in the presence of the mediator, or do you tend to excuse the mediator while you're talking about the case with your client?
I never excuse a mediator unless I don't like them, but.
So it depends. If it's something new, for instance, if we are talking about a new theory of liability and a piece of information, I'm going to excuse the mediator because I want, again, to control the process. I want the client to feel comfortable in sharing what they need to share. And I emphasize that, frankly, the mediator is not your friend. They are a tool. They are a tool to help resolve the case. And most mediators are very chummy and friendly, and that's part of their affect. It's like a tool in their toolkit. But if they come in and you're buddy-buddy and you say, hey, well, to be honest with you, here's what really happened, that's not effective. And so I want to make sure that everything that's going to come out of the client's mouth, I have an idea. It's like asking a question in trial you don't know the answer to. So if there's a new line, I will excuse the mediator and make sure that I understand where we're going with this. But beyond that, I do want my client to talk to the mediator. I want a rapport to be built in, and I want to have them a part of the process. And if I create a wall between them and the mediator, they're not going to feel like they had any influence over the day. That's counterproductive.
I have a comment that I'm going to invite a question from Malcolm. I'm going to share, there's several mediators in this room, and I'm going to share one of the great, most kept closely guarded secrets of mediatorship, and they may run me out of the club after I share this. But the reality is, and some counsel will let you stay in the room while they're talking about the case with their own client. Others will excuse you. Both are fine. But if you get to the point where negotiations break down, and we haven't talked about impasse yet negotiations, so looking forward to that. But we'll come to that in a little bit. But if you get to that point, and you're getting either to a point where the mediator needs to issue a mediator's proposal, or where they're going to start exploring as to what your client might be willing to do. If the mediator has been present in the room while you're discussing with the client, they get the benefit of getting sort of your evaluation and your client's response. That can be unbelievably powerful, valuable information for a mediator in coming up with a mediator's proposal or in starting to explore what the clients might be willing to do. So when I'm in mediations and people do that and I can get a read on where it's at, it completely informs and shapes my view of the case, and it starts going into the numbers. What the mediators should not be doing, and I don't believe most do, is disclosing that inappropriately with the other side. I mean, it's for the mediator, and sometimes there might be some discussion, but you have to really be careful with that. You don't want to embolden or empower the other side. Mark, you had a question.
But it's actually a comment. I like to be in the room if there's a private caucus, but I always ask first. The problem with sometimes being in the room is both the lawyer and the mediator start, and the client start negotiating with the mediator instead of through. And they think that because you're hearing, you are going to become their advocate. And so when you have to bring bad news back, they say, well, I thought that you were on my side. So I like to be in the room, but I ask first, and I take that, I ask you, and I'm there to listen.
I don't talk numbers with the mediator in the room with my client, so that's where I asked to excuse the mediator.
That's fine, yes.
I also usually excuse the mediator because there is a little bit of performance theater in this. And it's not because I think you need it, it's because my client needs to see me doing it. And so when the mediator's gone, we can sort of drop the pretense and I can stop beating my chest and say, all right, let's talk. Here are some bad facts, here are some good facts. How do we respond to this? What is our number one way to negotiate towards and how we're going to respond? If the mediator's there and I said that same thing, they're going to think I'm throwing them under the bus, that I'm just accepting as true. So it is hard. And now, David, we talked a little bit about making those side phone calls between the mediator and the counsel. Same thing. It allows a level of candor without the pretense of this over-the-top advocacy that your clients think that you're paying for. And I imagine you have a little bit too, in terms of what does your client expect to see you do for them versus what you're doing behind the scenes to get to the right number.
And something you said earlier, Joe. Yeah, you don't want, if there's times when you don't want your client to talk directly to the mediator because of the filibustering and just kind of going off a bit, I would challenge you on that simply because I think that's important for clients sometimes to get things off their chest in front of someone other than their attorney. And so sometimes that, and I had this in mediation a couple months ago, the client kept saying the same things over and over again, how it didn't make sense, how pissed off he was. And I realized that was, he needed to do that. So sometimes clients need to do that.
Oh, the catharsis of their day in court, that's a entirely different issue. And if they need it, that's usually, again, something I'll share in the pre-mediation conferences. You need to come in and do your whole song and dance about confidentiality and the voluntary nature. Then you need to let them unload on you. Because they've had this built up and they felt like they're a stick in a moving river and they hate it. They don't feel in control of this at all. And so you have to give them a bit of the control back, and you're going to have to spend 45 minutes listening to them talk about how they founded this company 50 years ago, and here's what they've done, and how good they treated everybody. It's important to the process. And so I'll identify that up front. I mean, how much armchair psychology do we have to do? It's a lot. And that's how what you have to do, is to be willing to sit there and to hear it. So I completely agree. There are other times, though, when I know they're not going to say either intelligent things for their case. It's the I can't be racist, I have a black friend. I mean, there are some positions that are really unfortunate that I know they're going to want to take. And so I'm going to shut that down. And there are other things that are just, they're rambly. They may be old or distracted, or there are lots of other reasons why I'm not going to allow that conversation to take place, or going to discourage it. And I appreciate City saying you all, when I'm talking to mediators and saying, here's what I need from you. If you can follow that set of instructions, then it'll help the mediation move forward. I'm not going to tell you something that's going to get in the way of mediation.
I disarm the catharsis, and I tell my clients that that's going to be a tool that they'll use against you, so let's talk about how you can get over this without a mediation.
Well, that leads to the next question. And I think Joe started answering this, but we're going to ask you, what do your clients most need from the mediator during the mediation session?
Not to be berated for hours, because that's just as unhelpful as the joint session. And then ultimately, is this case going to settle? What are the numbers? We also don't need somebody that just comes in and says, what's your number? This is their number.
We've all had
How about your number? So there's a middle ground between that. But for the catharsis, that a lot of mediators say, oh, you're going to feel so much better, trial's so difficult. And I say, look, that's what the system's set up for. The system isn't set up to pay somebody $30,000 to decide your case and tell you how much money you should get. It's set up for 12 strangers to tell you, and we're gonna do that. If they won't pay something, well, we're gonna walk out of here. And so I prepare them for that, and I say, look, you gotta think about what's gonna be something that will make you happy. And there's this really great podcast by, I'm forgetting her name, a football telecaster who went and got a great verdict. She won lots of money for the new photos that they came in. Do you remember?
Aaron Andrews, right?
Aaron Andrews. And she was talking about no matter what that verdict did for her, she still feels the pain and harm that that caused her. And when I first heard the case, my initial reaction as well was like, well, at least she was young, she looked good, like, what's the problem? And, but then when I heard her perspective and how it's still causing her harm and how the verdict meant nothing, I tell my clients, listen to this. This money isn't going to solve the harm that this has caused, and that's the only thing that we can deal with at mediation.
When I was first beginning my mediation work, I went to a seminar and I sat next to somebody who told me a story about how they'd done a trial about a wrongful death of a youth. And they went to trial and they got a fantastic monetary award. And she went, and after the verdict came in, she went to the client and said, we got this award. And she said the client didn't really respond. And she didn't seem very pleased. And she said, what's wrong? And the client said, you never asked me what I wanted. And she said, well, what do you want? She says, what I want is I want a park bench with my son or daughter's name on it. And she said, well, you got tons of money, you can pay for that. And she goes, no, but I want them to pay for it. So there was a splitting out between a judgment that was tons of money and a voluntary recognition of wounding her hurt. So a month ago, I was up in Martinez doing a settlement conference, and there was somebody in a personal injury case, and they were super hurt emotionally. And I said, look, courthouses are filled with people who have been wronged. That's why we have courthouses. There's people here every day. And we started talking about this emotional hurt and how do you best get through that. But these non-monetary considerations, respect and control and acknowledgement, those three, the value and the importance of those in settling cases cannot be overstated. So what comments do you have on that, either David or Joseph or
Well,
Ray?
I will say, one of my early mediations, there was a sexual harassment case, and talking about the non-monetaries, I knew that the plaintiff wanted to say something to the other side, to talk about, what Aaron Andrews was saying, how it affected her. But I also knew that it would summary the case if that was allowed to happen prior to any sort of settlement. And so these ancillary terms and she also needed an apology. And so to get around that issue of, because I think it's a big issue, is will these comments summary the case? To get around that, I had each side prepare a written statement that I was going to bring to the other room and read, but not give. And then I was going to give back the statements to the people that wrote them. But I also only was going to do that after the agreement was signed. Because I knew that reading, what the plaintiff wanted to say to the defendant, especially that the defendant had his wife there, which made it very difficult, not a sexual harassment case, I knew that would completely destroy any negotiations. And so you have to balance the apologies and statements with what's going to get the case settled. So I got the case settled, everyone signed, then I read it, and the defendant, the wife stormed out and said, we would have never settled this if that was read for him, which was exactly my point. So you just have to be careful with what is going to be said.
I had a case one time where it was family, big fight over money, family money, and I got a sense that one of the parties, older guy, was financially well set. And finally I looked at him and I said, is this case about money or what money represents? They said, oh no, it's about what money represents. And I knew it wasn't about the money. It was like respect and acknowledgement as expressed in monetary terms. Sometimes people will say, I don't care how much I get, I just don't want them to get more. So it's not about the money. It's about position and respect, especially in family or long relationship ones. it's so critical on this stuff. All right, let's talk about the money. So negotiation strategies. How do we best handle negotiation strategies once we're talking about money in order to bring this to conclusion?
That's a big topic. Yeah, let's just
Give us the answer.
get the answer to everybody.
I have to tie to something, like,
Reveal your secrets.
where does, how, if you're gonna pin out the numbers, does it make sense? And that's, I work with that with my client, I work with that with the experts, because if I just say a number and it comes out of the air, it doesn't make sense, and I can't sell that number.
It's absolutely, our numbers have to be grounded for them to be appreciable in my room. And so when we look at it, if we've got someone who made $100,000 a year, and the initial demand is $25 million, okay, that's 250 years of pay. That seems perhaps a bit exaggerated. Maybe it's bad math. But when you see these huge demands that are not well tethered to economics, and I know that there's a divorce between economics and non-economic damages, I don't want to get into that. But for us to appreciate the numbers, it does need to be grounded a little bit in terms of weeks and months of pay, what is the emotional distress damage. These big round numbers don't provide anything more than just sort of whispers and aspirations, and they don't help. And same with my number, I always like to provide support. Hey, I'm gonna make an offer, it's gonna be $200,000, $100,000 of that is economics, $50,000 of that is emotional stress, and $50,000 is attorney's fees. At least I have grounding and support for my number, because if I just say 200, now we're just throwing numbers out, and it doesn't allow, one, the negotiation to take place, but also from my side to rationalize the support. And then if you dial even a deeper level, I do have some clients that are very myopically focused on how much the plaintiff will get. They don't care how much the lawyer takes, they don't care how much the IRS takes, they want to know how much Bob gets at the end of the day, not Bob. And Bob can have more. But that's a serious consideration, and sometimes it is almost sad. Sometimes, a really robust severance offer will have been made early in the case. It'll be rejected, we'll litigate for a couple of years, and then the number we put out after the lawyer takes their cut, and the mediator gets paid, the IRS gets paid, the amount of money they take home is the same or less than the severance demand was. For whatever reason, that sometimes makes my folks feel better. Silly, but there's a rationalization of the process about who gets what and what's fair, and this equity in the process that may not be appreciable, that they don't think of defense as having that. We get sometimes painted a bit more as robotic or this behemoth that just has dollars and cents and accountants and whatnot. So there is a very human side in our room as well.
I was gonna ask Maria though.
For what?
Talk about the money.
Oh, I mean, just rationalizing it some way, this much economic damages, and one thing I've been looking at a lot more that I didn't look at when I first started practicing is when somebody has a severe harm, a lot of people don't go to therapy for social reasons, because of their age, religious reasons. So what is it that they do for therapy otherwise that we can prove damages? Do they talk to their wife? They talk to their priest? Do they all of a sudden have high blood pressure? Or we had a case, we got a $900,000 emotional stress damage award from a jury in Tulare County, of all places. And the jury was most compelled that he couldn't go to the doctor. And that, fear of you have you're diabetic and you need a knee surgery, and now you can't go to the doctor and have your surgery. Like, what is that emotional harm causing you? And so we deposed his doctors to talk about, someone had knee surgery when they should have. What would the outcomes be, and stuff like that, and looking at other ways to deal with emotional stress other than you went and paid $100 to a therapist once a week and were diagnosed with PTSD or something.
So what kind of negotiation strategies by the other side are counterproductive to getting the case settled? What do you see happening in mediation for the other side is non-communicating, not telegraphing the position well? What is it that sort of scuttles you sometimes for maybe with not like study?
Start off with increasing your demand from pre-mediation to the first move of mediation. I can't handle it anymore. It's simply, you have a $300,000 pre-mediation demand, and you show up and it's $3 million. I leave. and usually I'll discuss this in advance. This needs to be your starting number. If you're going to change, you have to let me know at least 2 weeks in advance, and we can cancel. If this is your new valuation, great. But more and more plaintiffs' attorneys are taking this tactic, and I think it's to make their original demand seem more reasonable and to try to end up at where they started. And it is so counterproductive in my room where everyone thinks that I get screamed at, they're acting in bad faith. Why are we here? How about we go backwards? How about they pay us? And now I gotta spend 2 hours unraveling this if we have any shot at resolution. So if there is a temptation from the plaintiff's bar to move backwards from where you were, you have to tell me in advance. If you put it, even if you put it in your brief a week in advance, that's not that helpful. I need it 30 days in advance, and if it scuttles the mediation, then we cancel the mediation. But to show up and then to 10x your demand is so unproductive, and yet it's happening probably in a quarter of my cases now.
I would say the thing that makes me the most angry and ready to walk out of the room is starting a demand with less than the cost of mediation. I'm done.
No, it's 6 in one hand, half a dozen in the other, where we're not showing respect to the process and to each other for showing up. Especially when I require that the plaintiff's counsel and the defense counsel both put in on the mediation, 50-50 split, 70-30, I don't care. It needs to be something, because we need to be invested in the process, and I can't spend 100% of the mediation fee to give a bully pulpit to the other side, because I've been burned by that enough times. It'll never happen again. There are a few plaintiffs' counsel that I'll agree, because I trust them to not be that way, but that's few and far between. But to your point, if I show up and I say, all right, opening offer is $1,000, and I know you spent $10,000 on Bob, that is disrespectful to the process. I think it is bad faith. It's just the same way if you show up and now your demand's 10x of what it was a week ago. I get what you want to do, but it's not productive in my room. It makes me mad, it makes my client mad, and then it makes everybody want to storm out. Just say goodbye to $10,000, you can keep it, we're done.
So thank you. The reality is, the back and forth that we see day in and day out in mediation is really nothing more than a technique. It's a technique. It's a technique for figuring out where the other side's at and for making sure that the offer's going in a very measured way. So by having the plaintiff doesn't want to leave money on the table, the defendant does not want to give away the store. By having a demand and offer going back, you know where the other side's at, you can see if they're moving at the right speed. It's a very measured way of making sure that everything is understood and people kind of can size each other up. The problem happens, is, and I see this again and again, we all do. I mediated 2 months ago and someone gave me a phrase I'd never heard before, but I've used it 100 times now, which is if you hang the meat too high, the dog won't jump. And so, the reason, of course, why people come out, sometimes plaintiffs, with these huge amounts, they're trying to move the anchor point up higher, move the bracketing up, get it up into a different realm. And if it's just outside the value of the case, you're just not going to get engagement by the defense. You're going to get some lowball offer. You say, well, if you want to be that way exactly you described, we'll do this. So a lot of times what happens is, in my case, you get demand offer, impasse. People won't talk. They don't want to telegraph where they're at. And it's fascinating because what happens is if you get them split off in a room and you start saying, where are you really at in this case? If they think they can trust you, you'll find out that many times they're in a very different area than what they're talking about because they don't want to communicate that to the other side for a very legitimate concern that the other side will use that as the next negotiating point and use that against them. So they're not going to telegraph until it gets down in the right realm. So what happens is if you can use brackets, sometimes that's effective. Sometimes you use a mediator's proposal. If you absolutely can't get anywhere, that's not my personal favorite because if you do a mediator's proposal and it's not accepted and both sides are stretched, you have someone who's demoralized who's made the offer to get there. And so it's like they don't want to negotiate anymore, they want to go backwards. So you can use techniques that kind of explore where the parties are at and then see if they're in the same realm you can get a settlement, but that requires people to trust the mediator, and a lot of times people aren't willing to do that. When they are, it can be very effective. So Joseph, what comments you got on that?
I mean, Bob, you got the right idea. I mean, ultimately, it's finding out what's the real numbers, what are the silly posturing position of the case, and that's about everything from pre-mediation to the day of. And I always joke that nothing real happens before 2 o'clock. I mean, that everything before that, before 2 o'clock is performative. it's chest beating and peacocking and it's everyone showing off, and then it's not until somebody goes, that's it, we're leaving. Then the mediation begins. And so, and if you do a half day, the whole process is accelerated. I actually like the half day because it dispenses with a lot of this garbage. And so I do like the idea of getting people to the right stage, but like most negotiations, you have to go through the dance. I tried to just reach across the aisle and say, look, we both know where this case ends up. How do we start there? And it doesn't work. You have to go through it, maybe because my client needs to feel like they really gave it everything to get a low number, and maybe the plaintiff felt needs to feel like they at least lobbied for the grand slam. I don't know, but in any event, you have to go through the dance. And I do want to hear from Maria, but then we want to open up a couple questions.
Sure.
Because I know I've got.
We can just talk.
Just real quick to that, I think there's a lot that leads up to it, where there are times that my relationship with the defense counsel becomes a problem for settling the case because I don't like them. I think that they're sexist, I think they're racist and rude. No, like for example, I have a case where the defense counsel said, oh, your client only was getting promotions because she was sleeping with the boss. I'm like, wow. How many times have you ever heard anybody accuse a man of that? Like, that is really sexist, and I can't believe you felt comfortable to tell me that. And now I don't want to settle that case because of the comments they made to me. And then they filed an MSJ saying that she was having an extramarital affair. Well, she wasn't. She was having a consensual relationship and going through a divorce. Like, why do those things? And that's, to me now, I feel like I'm in this battle, and I'm gonna show them something. And it doesn't have anything to do with the case. It's just the conduct between the attorneys.
It wasn't me, by the way.
Questions?
I have,
Speak loud, speak loud so everyone can hear you in the background.
I have a question and a comment. When I talk to counsel on the phone, I do a lot of employment cases as well. And when I talk to counsel on the phone, I ask this question. Tell me 3 things about who your client is that I'm not going to get from reading the brief. In other words, what is making, what is she a bus here? Sometimes my client's a very religious person, and they don't believe in whatever. Sometimes you hear things like, my client has had issues like this before. Whatever it is that you hear, I want to know who's the client. What is it that I'm going to need to know to gain their trust? That's the first thing I always ask. Tell me 3 things that are not in your brief and not in your brief. The second thing I want to ask you guys is this. Sometimes these cases, they settle within certain ranges. So I don't mind asking the parties, what do you think the settlement range of this case is? Not the trial range, but that's going to be way out there. What's the settlement range? And then I'll tell you what I'm finding lawyers for plaintiffs especially not having done before they come to mediation, is having talked to the client about if the case settles at this number, or at this number, or at this number, what is the client going to end up with? So they come into mediation not knowing what the cost. I've got to call my office and talk to the billing person to find out what the costs are. The client is sitting there and wants to get the case settled. Or they have not talked to the client about what the net to the client is going to be. Because if you're trying to settle the case with a component including attorney's fees, who gets the attorney's fees? So some of these things are not discussed with, I see it in PI cases more than in employment cases, frankly, is they've not talked to the client about what the net is going to be given the series of potential moves.
Yeah, in PI cases, it's very difficult too, because you have the lien issue, right?
Of course.
So, but yeah, definitely, it's important.
I try to circumvent that. I am a self-professed nerd. Love me some good numbers. They're not an Excel spreadsheet. I don't immediately fall in love with it. It's weird. But I will take the first set of numbers and see if there's any patterns. On my Excel spreadsheet, I have a column for patterns, and I put in the first demand and the first offer, and then the move, and then I'll see if that stays consistent. Where does it lead? And that's a way that I've gotten people to tell me if that crossover, where the numbers cross over, is that palatable, is it not? Well, you know, and to narrow the playing field, I'll see if I can get people to stay on that pattern for a while, even if I know it's gonna diverge from it eventually. But I'm just trying to find any information we can to get to that line.
We have time for one more comment from Joseph, and then we're at time, so I'm sure we can stick around and answer specific questions if anybody else is.
Happy to, and just to Malcolm's question, I really like it, what do you think the settlement range is? However, and I got 10 seconds, I know.
No, I'm just.
Getting the hooks.
That's exactly what I'm in for.
The problem comes
I think
with
it's all
trusting a mediator. So the only way you trust it is through repetition.
That's what I'm here for.
Or through having someone vouch for you.
You should.
And so I have had mediators that ask me questions and I give them an honest answer. Or during the side conference where they pull me out and say, okay, what number are you really targeting? And I tell them. The next time they come in my room, they will give away the ghost in front of my client. Now, it's all on the defense side. However, I gave them that number in confidence. And so if that number gets used against me, that particular mediator will never be used again. And that's a black mark, and then not only that, but I'll share that within my firm. That, hey, I had this experience with this mediator where they gave away a confidence. And so bigger and beyond the one case, I do think that building those bridges, those relationships and trust it's over the course of a career. It's not any one mediation, it's one issue. So it's important that we maintain credibility. I don't lie to my mediators because I intend to build that relationship. And I need them to really carry the water of trust when I do tell them something, either that I don't let my own clients know, I share with them, hey, they're willing to go to 100,000. Let's see if we can't get it for less. If you come in my room and say, Lordan said we can do it for $100,000, I'm done. And then so are you in terms of my mediator test. So I think the trust and the relationship is so important, and I know that we're over, but I wanted to say that. Thank you all for being here.
Okay.